All right. Good afternoon, everyone. My name is Alexis Alvarez Bartholomew, and I am so excited to be here with you as the Director of Statewide Training, talking about fair housing in part two of our Fair Housing Boot Camp training. For those of you who joined us in our part one session that was last week, welcome back. For those of you who are just joining the boot camp for their first session today, welcome. Thanks for being here. Um, First and foremost, I'd like to say I usually do introductions of my speakers and I read their bios, which are well deserved. But because this is a training series and we're going to be here for six sessions together, rather than reading the bios again and again and again, what I've done for this session and what I will do going forward is I've posted the bios of our speakers, Pia Molina and Joseph Cordova, here in our chat. So feel free, as I'm giving the housekeeping announcements, to look over their accomplishments because we really do have rock stars with us here today. So before moving into the content and the other stuff, I always want to give you your housekeeping announcements. As I mentioned, this is part of a training series that is focused on all things fair housing. So today we'll be talking about disability protections. In next sessions coming up, we'll be talking about LGBTQ protections, protections for families. So this is a building and growing series. The second piece of housekeeping announcement I want to mention is this is being recorded. And a copy of the recording will be sent to all of you who are present, all of you who registered, all of you who are here but maybe have to hop off and put out the fires that you're always putting out in legal aid. So don't worry, it's being recorded, and a copy of that recording will be sent to all of you automatically via Zoom in your inbox. I am going to drop my email into the chat because sometimes those Zoom emails don't go through or they get missed. You can always reach out to me and I will send you the copy of the recording for this session and our previous session or any other session that you need. Third piece of housekeeping announcements are CLE credits. You know, some of you are here to learn about fair housing. Some of you are here just for CLE credit. Some of you are here for both. Either way, I've got you covered. This is accredited for CLE credits, one general CLE credit for this session. And I think I mentioned this before, each of these sessions is independently accredited. So every session there will be a new CLE code and a new CLE credit for you. Third piece of housekeeping announcements, probably my favorite, is questions and answers. For those of you who joined us in session one of this training series, you all were awesome. You brought your thoughts and your questions and really created rich and thought-provoking discussion and question and answer time. So please do it again. It's our favorite part, interacting with all of you, hearing your thoughts, answering your questions. So please don't be shy. Drop your questions into the chat or the Q&A and we will answer them as we move along. Final piece of housekeeping announcements, closed captions. Those are enabled for anybody that does need extra accessibility. If you're having any trouble with those, feel free to message me separately, or like I said, as soon as I stop talking, I'm going to put my email into the chat and you can ask me for anything that you need. I'm happy to do it. So as I said in my first introduction of session one, I'm really excited to be here, not just to talk about the subject matter, but to be highlighting two of my colleagues who do amazing work in this sphere. And with that being said, I'm going to turn it over to you, I think Joe first, and then Joe, if you want to turn it over to Pia, the floor is yours. Thank you both for being here. Thank you for doing this. Thank you for spearheading this boot camp.
Yes, hello everybody. Welcome again. I'm just going to say a quick hello. It's great to have you guys all again. And just repeat what Alexa said. Please jump in, interrupt us if you have a question, chat box or anything like that. We try to keep our attention on the chat box. We'd like to answer questions in live time as much as we can, but we will make sure we have time at the end for Q&A as well. So I just want to say a quick hello. It's great to be with you again. And I'm going to pass it on to Pia and we'll get started.
Hi, everyone. Thank you so much for being here today. Yeah, let's get started. So today we're going to be talking about protections for persons with disabilities. Okay, so the agenda. So first, what is disability under the Fair Housing Act? It's a specific protected class that we'll be talking about today. What is discrimination on the basis of disability? How you can discriminate in the Fair Housing Act when it comes to disability. Joe will talk more about reasonable modifications and reasonable accommodations. And then something we do a lot, which is service animals and emotional support animals. So the Federal Fair Housing Act, that's what we're talking about today, and we're talking about disability, but just a brief overview about what the act is. So it prohibits discrimination in housing-related transactions because of a person's protected class. So the 7 protected classes under the federal one are race, religion, color, national origin, sex, disability, and familial status. So as you can see in this portion, the disability portion was added later, and it has its own specifications and its own kind of rules and section in the act itself. I guess I can go over them quickly just to sort of overview. Race refers to heritage, lineage. Color is the color of your skin. Religion is any religion that you practice or not practicing religion. National origin is where you or your family might be from. Speaking a different language also counts. Sex is both sexual harassment and gender identity and preference. And disability we'll go over. And then familial status is anyone with children under the age of 18 in the home. This includes pregnant women and foster parents. So disability in the act, it is both a physical or mental impairment that limits a major life activity. So major life activity is walking, talking, thinking, breathing. It both covers diseases and past drug addiction. And is also a record of having the impairment or being perceived that way. So even if you're in a wheelchair for a short amount of time, it could be perceived as a disability that's longer term.
And real quick, I like to jump in on this for a moment. We get a lot of questions about drug addiction, especially from housing providers. When we give this presentation to housing providers, a lot of them, I don't want to say they push back, but it opens the door to saying, well, what are we supposed to do when, X happens, when Y happens? And I always ask the question, I'm going to ask the group here, and feel free to jump in the chat box with just some quick answers. So drug addiction qualifies as a disability under the Fair Housing Act. What about active use? What about active use of drugs or alcohol? Is that a protected class? Does that qualify as a disability under the Fair Housing Act? This should be an easy question. See if anyone wants to jump in the chat box. Does active use of drugs or alcohol count as having a disability? Let's see what we have. So no, I don't think so. Depends. Okay. Oh, it could be medical. There we go. No, there's going to be a lot of things that say, well, hold on, what's the situation? So drug addiction qualifies as a disability under the Fair Housing Act if you are identifying yourself as an addict and you're in rehabilitation, and that addiction is something that you are trying to overcome. So you recognize, I am an addict, I am a previous user. Now, I often ask housing providers, well, what about a relapse? I'm going through sobriety. I go through I go to my daily meetings. I have therapy. I'm going through everything that is in all my resources available to me to beat this addiction, or to at least, live my life without the addiction running my life. But I have a relapse. Well, I always remind housing providers, relapse is a part of rehabilitation. It just is. It's very rare that you meet somebody who quits cold turkey and they never use again. Relapse happens. So a lot of housing providers say, well, what if relapse led to, a DUI, drunken, someone drove their car through, one of our who is identified as an addict, previous user, they're going through the steps, and they have a relapse moment, or maybe one night they're in the common areas and they're a little bit disorderly. But they're not breaking any rules. They're just kind of a nuisance that evening. My recommendation to housing providers is to recognize that incident as a part of the addiction. Try not to qualify that as a major strike against their tenancy, because that could come back in the form of I'm an addict and I relapsed, and it's not happening routinely. And the small nuisance you saw last night, if you use that against me, it's going to come across as disability discrimination. So that's just one example of how addiction is going to have some gray areas that I always encourage housing providers to say, let your case by case response to things recognize those gray areas, because they will be happening. And I didn't even mention, we have that great comment from Vilma saying, what if it's medical? Absolutely. What if it's medicinal marijuana? And that's what's been presented to you. And then, or not even medicinal marijuana, I'm sorry, what if it was painkillers? Your addiction is to painkillers and it was prescribed by a doctor. There's so many different, offshoots and branches of this conversation we won't get to today. But again, an active user is not necessarily protected, but a relapse from an addiction might be. So I like to jump in at that point just to help people understand just how gray this conversation can be. All right, I'll let you jump back in, Pia.
Thank you, Joe. I think it's important to kind of clarify that, because I think we do get a lot of questions from housing providers. And so what are the ways that you can, violate the act when it comes to disabilities? So denying the person with disability housing, discriminating against the person that is associated with the disability. So the act also covers any caretakers of the person with the disability. Denying people with disabilities access to the facilities, to parking privileges, or other services offered to all tenants. Putting people with disabilities in a certain area of the housing complex, so saying that maybe all people are going to go on the first, with disabilities are going to go on the first floor, and denying any modifications or accommodations that are being requested.
Yeah, and I like to point out the fourth bullet: segregate people with disabilities to certain areas of the housing complex. One of the common questions we get from tenants is, I live on the second floor, or I'm trying to apply for this housing, and because of my wheelchair or because of my lack of mobility, I requested a first floor unit and they denied me. And then on the flip side, the housing providers say, well, we always accommodate people with disabilities, we just have them live on the first floor. And so you might be thinking, oh, perfect. Both instances are instances of fair housing violations. In the first instance, saying, no, you can't live on the first floor because, we have a waiting list and we're not going to accommodate your request. And, case by case situation, we're just going to continue to deny. It might eventually become a fair housing violation. In the second scenario, the fact that you put everybody with disabilities on the first floor automatically is also a violation of the Fair Housing Act, because you're segregating people. What if you have someone with a disability who doesn't want to live on the first floor? So you can see how the exact same remedy or the exact same situation from both perspectives could be both a remedy and a violation at the same time. So again, these case-by-case situations are extremely important, especially in the world of disability-based violations, accommodations, and modifications. There really should not ever be a blanket policy, other than we will always respond on a case-by-case basis.
And so this is kind of covered along with the person with the disabilities, any association with the person with disability. So here it says, Tom and Sarah are a married couple that are looking for housing. Sarah has a walking impairment and uses a wheelchair. One day, Tom goes to check out a rental on his own because Sarah wasn't feeling well. The visit at the rental site was going very well. The landlord showed Tom the available unit and invited Tom to complete an application. When Tom asked the landlord if they could have an assigned parking space for his wife, because of her disability, the landlord said that they could not provide an assigned parking space and the unit was not appropriate for people with disabilities. I'm going to let you jump in, Joe, if you want to say more about this.
Well, one of the things we try to pay attention to when we look at someone's fact pattern that they bring to us is how many violations of the Fair Housing Act occurred. It's important when you're putting together your notes and maybe assisting somebody filing a complaint that you're not filing a general complaint with like a large story where the receiving party, whether it's HUD or a FAP, is trying to pick through the details of where the complaint happened. It's important that you specifically identify and, alert, this is where it happened. And so I'm going to throw this out to the group here, and, feel free to jump in the chat box. How many different violations of the Fair Housing Act actually occurred in this very short paragraph, in this little fact pattern? You might think, oh, this is a violation. It is, but where and when? How many different times? Let's see what folks respond with. Where, when, how many times was the Fair Housing Act violated here? So I see at least two, possibly three, even though it's from the same instance and it's the same sentence. Yeah, thank you, Tamara. Two, yeah. One is when he denied the request for an assigned parking space. Okay, you might say, well, he's not even a tenant yet. Him and his wife don't even live there yet. Okay, but the fact that it was already responded to as if you become tenants and you ask, we will deny you. That's like it's like a pre-denial. So we're gonna, you don't even live here in the first place. And then the second is in the same sentence when he said, this unit is not appropriate for people with disabilities. That's a violation of 804C. It's a public statement. This is not appropriate for people with disabilities. This is not appropriate for women, Black people, Catholics. It doesn't matter what you fill in the blank with there. That's no longer just a disability-based discriminatory statement. That's an of all play fair housing. So one sentence, two violations. And if I'm filing a complaint based on this, I'm highlighting both of those instances. And then the other thing where you might say 2.5 or 3 is that Sarah's never even there, but she's still being discriminated against through her husband. And so the violation occurs because under 804F of the Fair Housing Act, it includes members of the household, persons related to and associated with the person with disability. So Tom is being discriminated against. He doesn't have a disability, his wife does, but he's still being discriminated in housing due to a household member having a disability. So this short little fact pattern of just a common little sentence that one person says, you might be able to say the Fair Housing Act was violated 3 different times in one sentence. All right. I'll take this one. Yeah, this is my turn now. So when we talk about reasonable modifications under the Fair Housing Act, we are talking about changes made to the actual structure of the unit and the home. So the exterior, the interior, and the common areas, okay? Before these changes take place, the tenant must seek approval. They have to request. I get a lot of phone calls from tenants saying, I put this in and then the landlord told me I have to take it out. That's a violation of Fair Housing Act. Well, maybe. Did you ever ask for it though? Well, it doesn't matter because they have to approve it. That's probably true, but you still have to ask for it because there might be a situation where what you're asking for is not reasonable. We have to consider that word reasonable modification. So if I'm on the 7th floor and I request a wheelchair ramp, that is not reasonable. That is too steep. It would wind around the outside of the building. Like there's no such thing as a 7-story wheelchair ramp. You have to get approval for these modifications so that the landlord and the housing provider can determine, yes, this is reasonable. Yes, we've approved it. Okay. The person with a disability, if it's private housing, the person with the disability can pay the cost. So they can say, yes, you can have this modification, but you have to pay for it. Unless it's federally funded or subsidized housing, at which point the housing provider pays for it. And even then they can say no if it's an undue financial burden, okay? So those 2 prongs have to be satisfied. It's reasonable and it's not an undue burden. If the private housing provider says yes, again, they can say yes, but you have to pay for it. The housing provider can also say, not only do you have to pay for it, but I'm going to ask you to put things back the way they were when you got here. So you have to restore it back to its original state. We often advise housing providers, don't do that unless it's absolutely necessary. If you have somebody who lowered the countertops because they're in a wheelchair and you need them to restore it to the way it was when they move out, that probably makes sense. But if all they did was add a grab bar in the shower, don't make them pay to take that out. who doesn't want a grab bar in their shower? Like that's not a big deal, okay? So don't do it out of spite because that might actually come back and bite you and as another form of discrimination. Even though you have a right to say we're going to have you restore it, if it's an unreasonable restoration, that might be discrimination. And like I said, landlord can deny requests are unreasonable, results in an undue burden. I want to ask the group, or maybe I'll just bring up this scenario. This comes up a lot. A lot of housing providers say, well, what if we say yes and we want them to pay for it, but we're concerned with the person they're going to have do the fixes, okay? Like we have a maintenance crew. We have a team of people that go in their full-time jobs. We have a full-time crew, and they're constantly using our equipment, our tools. We have a particular size, nuts and bolts that we use so that when our team gets in and out of units, we can, manage 200 units at the same time, as opposed to have to start from scratch with each one. So we want to make sure that the contractor that does the work is not only a licensed contractor, but is going to do the job that we, our team is going to be able to get in there and not have to, figure out what this other guy did. Well, I always advise housing providers, if you're going to say yes, and yes, that the tenant has to pay for it, but you're insisting that they use your crew, you're going to have to come up with some sort of accommodation or mediation or mitigate the cost. So if the tenant says, I have a licensed contractor and they can do this job for $900, and the housing provider says, no, you need to use our team and it's $2,000. By disallowing the tenant to use a licensed contractor at a cheaper rate, you might have a business purpose, and that business purpose is going to be linked to, hey, if this person skips out on their rent or they abandon the lease 6 months into it, we have to get our crew in there and finish the job or take away the job. And it's much easier for us if our team does the building and then does the restoration later. That's a legitimate business purpose to deny a fair housing request modification. But if the resulting approval is that it's going to cost the tenant an extra $1,100, that's a slippery slope for me. So I always encourage housing providers, if you have a policy that says our crew has to do the work, then cut them the discount. Only charge them what that other contractor would charge. That's not a rule. I'm not sitting here saying that's what the law says. But my guess is that if a complaint was filed and you get into the details, a judge, a jury, administrative judge, an investigator is going to say, why were you charging them $2,000 for something that they could have gotten done for $900? You're going to have to answer to that, okay? And if you don't have enough of a legitimate business purpose, that might be a violation on its own. So housing providers are always encouraged, if you have to say no, find a way to say yes. Find something in the middle, negotiate that yes, negotiate that no, because denying modifications is one of the most common complaints received by HUD every single year, and you don't want to be on the wrong end of that. All right. All right, this is an interesting one. I'll read this one to the group, see what you guys think. John, a person with a disability who uses a wheelchair, views a condominium he is hoping to purchase in a new multi-story building. When John arrives, he finds there are no accessible parking spaces in the building's parking lot. When John tries to enter the unit, his wheelchair can barely fit through the door, and he bangs his arms on the way in. Inside the unit, the thermostat and light switches are all too high for him to reach. The building has a fitness room, but he cannot look at it because the only way to get to the fitness room is to go up steps. So same question as before. I'd like to see from the chat box, has the Fair Housing Act been violated? And if so, where, when, and how? So has it been violated? When, where, and how? Yes, new multi-story building must comply with the ADA. That's correct. Yeah, must comply with the ADA. Has the Fair Housing Act been violated? So the ADA is separate from the Fair Housing Act. There's definitely an ADA claim here. The no handicap parking is, that's probably going to be a situation where the Fair Housing Act is violated at the same time as the ADA is violated. So I'll jump in here. One of the probably the confusing parts of this one is John's not a tenant. He's a potential applicant. In fact, he hasn't been denied housing. If John were to file a complaint today, the housing not being able to get, not being accommodators, there we go. If John was able to, if he decided, you know what, today I'm going home, I'm filing a complaint. The housing provider is going to say, he's not a tenant. We never denied him housing. We never said he couldn't use the common spaces. At no point in our interaction with John did we ever put up a stop sign to his access to housing. What the complaint is going to focus on is that it really wasn't available to him, though, in the first place, was it? You have this home that he can, if he wants to live there, he absolutely can. You've never said no. But you kind of give a constructive denial by making it somewhat impossible for him to move in. Okay. It's not ready for him. And so if he chooses not to live there, and then he calls up some of his friends, and maybe a lot of them have disabilities as well, and pretty soon 5, 6, 7 of them are, on a group chat, and they're like, we all went and saw that place too, and we all decided not to. Isn't that what a coincidence? Why did you guys decide not to apply here? Well, it was not accessible. Now we have a situation where a housing provider has a space where, whether it's intentional or unintentional, people with disabilities are choosing not to rent there because they don't feel like they're welcome there. This might be a violation of disparate impact, and it might just be differential treatment in general because you've set something up so people with disabilities cannot access it. One thing to keep in mind that a lot of people will point out, well, the thermostat and the light switches, they don't all have to be lowered at all times for anybody who might live there. That's true. Okay. You have to follow what the ADA says. Now, if John became a tenant and he requested the thermostat and the light switches to be lowered, then that would be a request for modification that they need to say yes to. As far as everything else goes with the common areas, it's probably in their best interest to update everything so that people with disabilities have a fair opportunity and a fair likelihood of filing or filling out an application and wanting to live there. You've denied them without ever having to say no. That's going to come back and get you. So this is I like this example because technically, does he have standing yet? He might not yet, but I think it's waiting for him.
Joe, I have a question.
Yeah.
Would it be a different scenario if they had said it was an accessible unit, but all these things were true?
I think so, because they're advertising it as accessible. And then when it gets there, it's not. My guess is that's going to be more of an ADA red flag, but I'm definitely sneaking some Fair Housing Act stuff in there as well, because you're misrepresenting the availability of the unit. And misrepresentation is going to fall under the Fair Housing Act violation as well. And the housing provider might be saying, how are we misrepresenting it? We're saying it is available. It's not, though. You're saying it is when it isn't. So the person comes by, sees it, and says, I don't want this. It's not really accessible. Thanks anyways. You knew what you were doing. So yeah, that's a great question. Thank you. All right. Well, let's look at the next slide here. So we'll move on to reasonable accommodations. This is different from modifications. So while a modification is a change to the structure, an accommodation is a change made to the rules, the policies, practices, and patterns of the housing provider, okay? Or maybe some specific services that they offer, or specific resources that are available to at this particular housing provider. Same thing, it must be reasonable, and it cannot impose an undue financial or administrative burden. As far as reasonable accommodations go, for the most part, in my experience, when people are telling me I asked my landlord for reasonable accommodation or I need this, it is reasonable. Okay. The definition of reasonable is pretty wide. Although I will say I've had some tenants now and then say, due to my disability, I lost my job. I have no income. Can you believe my landlord is still making me pay rent? I can. It's unreasonable to ask a landlord to let me to live there for free. If the accommodation was let me be late due to my disability, I have this Social Security disability checks that come in on the 8th, and you want rent due on the 1st. Can I get an accommodation for my rent to be due on the 8th? That's reasonable, and that's not an undue financial or administrative burden. But to simply ask for an accommodation, do I not have to pay rent anymore? That's not reasonable, okay? But for the most part, these requests are reasonable. And you cannot say yes, but there's going to be an extra fee or an extra deposit, or something like that. Oh, you want me to accommodate this? Absolutely, but we're going to add $50 to your monthly rent or something like that. Can't do that. An accommodation is supposed to level the playing field and make your living experience equal. Not yes, but it's going to cost you more. Okay. As far as making a request for an accommodation, the landlord is allowed to question to the point of understanding the nexus between the disability and the need for the accommodation, as well as understanding or confirming that the disability exists. But you, as a housing provider, you don't want to dig, you don't want to go into the weeds, and you don't want to approach it with skepticism. Enough needs to be enough. If I say I have a disability and my doctor writes me a letter saying that it's in my best interest of my patient requires an emotional support animal, my patient requires a closer parking space, the landlord is not supposed to be questioning the medical diagnosis and the medical prescriptions of the doctor. Okay. Same thing as at work. If you show up at work and you tell your boss, hey, I have this medication I have to take at lunch, the doctor's not going to call the doctor and say, well, it's in my medical, understanding that what you prescribed isn't accurate. We don't call doctors and question the medication that they're prescribing for our patients. So landlords aren't supposed to be questioning doctors' prescriptions. Okay. They are allowed to say, I don't understand the connection. You say that you have, I don't know, a physical, no, let's say you have an emotional disability, but you are requesting a closer parking space. I don't get the connection there. Well, I like to use this example of, let's say you have somebody who has PTSD and they request a closer parking space. And the landlord says, no, this is a scam. You're just trying to get out of this. You don't need a closer parking space just because you have PTSD. What if the PTSD stemmed from a traumatic event in a parking lot? Okay, I was assaulted in a parking lot and I have PTSD from it. And so the less time I spend in parking lots, the better it is for me. If I can park and go straight to my unit without having to walk through 3, lanes of a parking lot at night, my PTSD isn't triggered. Well, there you have it. The landlord's not really supposed to be questioning those things other than just understanding that, yes, there is a nexus. Sounds good to me. Check, this goes in the file. A lot of housing providers will employ, maybe they contract out to third-party organizations, and they've made a whole industry out of questioning the validity of accommodation requests. We'll get into that more here in a second. I understand that from the housing provider perspective, it only takes one person to ruin it for everyone else. But the numbers are definitely skewed in the favor of people needing it as opposed to trying to scam and get away with it. So it's unfortunate that those who actually need it are having to bear the brunt of the extra legwork for the people who really are trying to scam. And that's one of the things we're trying to do with our work here, is to let housing providers understand you need to get rid of those obstacles. Those are violations of the Fair Housing Act. So let's talk about this one here. Jane has a developmental disability that affects her capacity to manage her own finances. Jane tells her building manager that her mother will be paying her rent for this reason and asks if all notices relating to her rent can be sent to her mother. The building manager tells Jane that the management company has a policy of only sending notices to residents, no exceptions. Several months later, Jane receives an eviction notice because her mother had not known that Jane's rent had been increased. All right, I'm going to ask the group, the chat box, please. Is this a violation of the Fair Housing Act? And if so, how, why? And maybe look at it, devil's advocate. What's the housing provider's response or defense? So do we have a violation of the Fair Housing Act here? And if so, how? And what might be a proper defense to this? Or probably a losing defense, but what would the defense be? So mom is not on, okay, so that could be a defense. Mom is not on lease. Yes, it was reasonable accommodation for developmental disability. There you have it. Is it reasonable to ask, is there any argument? There we go. All right, he's doing great. So number one, is it reasonable? Is it reasonable to say, hey, can you include my mom on notices? Okay, is that an administrative burden? No, I just CC mom on emails. There's no burden there. I just CC mom. Okay. I'm not really having to go out of my way. So it is reasonable. And does it accommodate that particular disability? Absolutely. I have a developmental disability. Independent living is my goal. But in order to live independently, I do need a little assistance from mom and dad now and then. So please just CC them. Accommodation approved means I'm living independently. I like that response up there in the chat box. Mom is not on the lease. This might be the housing provider's pushback, their defense. I'm sorry, mom's not on the lease. We do business with the people we contract with. Okay, that's true. Okay. So maybe they say, absolutely happy to CC mom, but we're going to need her listed somewhere in the lease, or maybe an addendum to the lease that says we are given the right to connect with mom for matters of rent related questions, stuff like that. The housing provider does have a right to say, we're going to make an exception to our policy, but here's how we want to make that exception. That's okay. As long as they're aiming towards a yes, then they're allowed to do that. A lot of people also say, well, a lot of housing providers might try to argue, well, what about privacy? We have rules of privacy here with our tenants. We don't just go around telling third parties, information about our tenants. But remember, it's Jane who's making the request. She's waiving that privacy. The tenant has the right to say, I thank you for the privacy and the protection of my privacy, but I'm going to waive it in relationship to my mom here. The other thing that I want to point your attention to, if you guys are ever working with housing providers, if you ever come across a policy handbook or a housing provider use the phrase no exceptions, we have a violation of the Fair Housing Act waiting. Okay, no exceptions. Get rid of that in your policy handbooks, or if you're an attorney representing clients, be on the lookout for terms such as no exceptions. There always needs to be exceptions. That's the whole concept of the Fair Housing Act under reasonable accommodation modifications, is that you're making an exception or you're making an accommodation. So no exceptions is usually kind of that juicy area of someone's handbook that says, all right, well, how long until we have a violation on our hands? All right, nice work, everybody. All right, here's another one. A landlord has a no pets policy. Hint, hint, wink, wink. Jose, who is deaf, requests that the landlord allows him to keep a dog in his unit. Jose explains that the dog is an assistance animal that would alert him to several sounds, including knocks at the door, sounding of the smoke detector, telephone ringing, and cars coming into the driveway. Does Jose's assistance animal violate the pet policy? What do you guys think? We have a no, a fast no. Thank you, Tamara. Okay, yeah, that's great. It does not violate the pet policy, and here's why. We'll move on to the next slide here. No, it's a service animal. Nope, not perfect. Not a pet. Assistance animals are not pets. All right, let's look at this slide here. Got some pictures of some wonderful emotional support animals. Under the Fair Housing Act, there are two types of animals that are considered assistance animals. We call them service animals and emotional support animals. There is a difference between the two, and it's very important that we don't just nonchalantly kind of interchange the two terms because they are different. A service animal is trained and certified, okay? They're trained and certified to assist or perform a specific task. Under the Fair Housing Act, that means a dog or a miniature horse. I've heard that the dog and miniature horse it might be expanding, but I haven't gotten any specific updates or when or why it might include something other than a miniature horse or a dog. But for the most part, that's what the Fair Housing Act is saying. It's trained, it's certified, specific task. An emotional support animal is the animal is not trained or certified. They provide a therapeutic emotional support, and it can be a variety of animals, okay? The emotional support animal is qualified via the doctor or the professional's letter that says, my patient requires this emotional support animal, an emotional support animal, okay? Now that what used to be a pet is now an emotional support animal. Maybe it was never a pet. But remember, once something is an emotional support animal, it is not a pet. So when landlords try to say, sure, you can have that, but we do have a pet policy that says no pit bulls or weight restrictions. That's great. You guys can have your pet policy all you want. I don't have a pet. I have an emotional support animal. I have a service animal. So all your other tenants will definitely need to abide by that pet policy. I'm not violating it because I don't have a pet, okay? Now, a lot of housing providers will push back and say, yeah, but can they just let that emotional support animal, make a mess in the hallway or in the stairwell, or can they be barking all night? No, because that would be violation of the lease under, taking care of common areas, nuisance rules, and stuff like that. It's not that it suddenly has to abide by the pet policy. It has to abide by the, decent tenant policy, which is, if I'm in a wheelchair, I'm also not allowed to just, ram my wheelchair into the walls and create holes and stuff like that. No, none of us can do that stuff. So you don't have a defense to saying we don't allow pets because of the wear and tear. Okay, that might be why you don't have why you have a no pet policy, but it's not a pet. Humans also cause wear and tear. Okay, which means you cannot charge a pet fee. You cannot charge a pet deposit if it is a qualified service animal or emotional support animal. And we have some pictures down there. Yes, you can have an emotional support alligator. You can have an emotional support duck. The only I have seen in some court cases in the last few years are starting to become a little bit of pushback. I heard a case where a young girl, I forgot what state it's in, she was denied emotional support chickens. And the court specifically focused on the term, the necessity. And the court was defining necessity as what's needed is an emotional support animal, not this emotional support animal. That concerns me. I don't know how far that particular legal reasoning is going to go, or it's going to make it if it ever got appealed, or where in the country they're starting to use that. The reason why that's an important, and I want to make sure, I don't want to get too far ahead of myself. I use myself as an example here. I personally am not a pet person. It's where I lose friends, all that kind of stuff. I know that there are other people out there that say I'm a cat person, but not a dog person. I'm a dog person, but not a cat person. Okay. Myself, for example, if I had a doctor tell me, Joe, you would benefit from, and I feel you need an emotional support animal, I would look at that doctor and say, I'm going to get a second opinion, because a pet, an animal around me, an emotional support animal, it's going to increase my anxiety. But if they said, what about an aquarium? Okay. Be nice, feed some fish, stare at the fish now and then. It'll calm you down when you're feeling stressed. You can just walk over to the corner with the aquarium. I'd say, you know what? Actually, that does sound peaceful. That sounds nice. Yes. If my landlord said, no, you can't have an aquarium, but we'll let you have a cat, again, it's no, that's not needed. I don't need any general emotional support animal. The patient needs the emotional support animal that's going to provide that emotional support. It's going to meet that need. It's the same thing as if a landlord went into your medicine cabinet and said, hey, you can have medicine for your anxiety, but you can't have this particular medicine. I'd rather you take this. No, my doctor prescribes the medicine, not my landlord. Okay. We have a great question in the chat box. Love this question. How about a skunk or a venomous snake as an ESA? All right. We do have a little note here at our final slide. Maybe let me see. Maybe I'll jump into this and I'll come back to it. Yeah, we have this little slide here. All right, Edwin, I'm going to use your question to forth this little slide here. So, Jake the Snake. Perry has PTSD and delivers a doctor's note to his property manager, seeking approval for having an emotional support animal in his apartment. The doctor he met with was an online therapist with full credentials, whom he has met with twice. The animal he selects is a non-venomous snake, 3 feet in length and roughly similar in size to his arm, named Jake. The snake reminds him of one similar to the one his cousin had when they were kids, and takes him back to a peaceful part of his life when the snake wraps around his shoulders as he watches TV. The property manager refuses the request, stating that it will make the other tenants uncomfortable and that their pet policy is very strict. Okay, so a couple things to pick out here, an issue spot. Number one, this is a non-venomous snake. And I know, Edwin, your question was, what about a venomous snake? So the difference between non-venomous and venomous is safety. Housing providers absolutely have a right to say we have a legitimate business purpose to protect the safety of our other tenants. And so if you're bringing a venomous snake in here, you need to provide 110% guarantee that snake will not be a safety hazard to other tenants. Chances are you cannot make that 110% guarantee, so you might be able to deny a venomous snake for saying that the request is unreasonable. Now, if the tenant can respond and say, actually, it is reasonable, and let me show you all the things I have in place to prevent the safety concern, tenant might win that argument. Okay, it's the question of reasonable and unreasonable, and do you have a legitimate business purpose to say no? If it's non-venomous, but it's simply uncomfortable to other tenants, I'm sorry, we live in a society. There's plenty of things people do that make me uncomfortable, and I am positive I make people uncomfortable all the time just by walking into a room. But that's society, okay? We live in a community. You live in, in an apartment building. Uh, their dog might bother me, and I don't know, my bouncing a basketball in the middle of the night might bother them. So we're talking more about lease violations. You know, are you actually a nuisance? And if a non-venomous snake is not a nuisance to other tenants, well, then it looks like your neighbor has a non-venomous snake and you're just going to have to pretend it's not there. Um, we also mentioned that what if the landlord were try to saying, well, instead of a snake, why don't you get a dog? Well, look at his story. The snake takes him back to a peaceful part of his life when he was a kid. A lot of opportunities if you're experiencing an episode, PTSD, anxiety, a panic attack, you need to find that peaceful place. And if the snake takes him there, but a dog doesn't, then you can't say, we'll let you have a dog, but not the snake. It's the purpose. It's a prescription. This is a medicine for him, and this works miracles for him. Um, also, so, and then the question, there was also a question there, what if it was a skunk? Yeah, I mean, probably if it's that question of the nuisance. If the skunk is spraying, well, you might have to get rid of the skunk. Let me go back up to this slide here. Let me see if I can. Here we go. Okay. So the tenant, in order to get this approved, the tenant actually has to make the proper request and approval. Now, nowhere in the Fair Housing Act, in fact, HUD guidance, the DOJ and HUD joint statement guidance specifically has language that says a request counts when a request is made. It's best that it's in writing, okay? It's best that it's accompanied by a doctor's letter, okay? These are going to be the most often hard to deny requests. But once a request is made and the landlord is on notice that a accommodation is needed, the landlord is supposed to engage in what's called the interactive process. A simple denial is going to be a violation of the Fair Housing Act. We're probably going to say no, but let's figure this out is not going to be a violation of the Fair Housing Act. And if you just can't figure it out because you can't get over the hurdles of safety, nuisance, like the example of the skunk, I'm sorry, your particular skunk sprayed in the hallway. You have to remove that skunk. Now, we can't discriminate against all skunks because maybe not all skunks will behave that way. But your particular skunk or your particular dog bit the neighbor. That dog must go because I have a legitimate business reason to protect the safety of my neighbors. I can't say all dogs that size, that color, that breed can't be here because I'm discriminating against breeds and sizes of dogs. But once your particular animal is an actual safety threat or nuisance, now the landlord can step in and say, now we have to deny it or request that it be removed. But once that request is made, it needs to be responded to with a yes, but the landlord is allowed to seek enough information to just confirm that it's needed. There's a nexus, it's qualified professional writes this letter, and it should be approved. One thing I do want to note, and I know we're getting short on time, it does not have to be a medical doctor. It can be a therapist. And I've even reached out to housing providers and said, what if it's somebody who's experiencing domestic violence and they're at a women's shelter and they need an emotional support animal? And you got a letter from like a DV survivor program advocate. Most housing providers say, we'll take that. We're not going to make that tenant go get a doctor's letter. Okay. We just need some sort of confirmation that they've experienced this and there's a third party with professional credentials to confirm it. Does a DV women's shelter advocate qualify under the Fair Housing Act? It might not. We encourage housing providers to just say yes without challenging that. If they did challenge it, it's kind of one of those, well, who wrote the letter? You know, how much experience do you have with them and all that kind of stuff. But it doesn't have to necessarily be a doctor. It can be a qualified professional's letter, but it does need to be on letterhead and signed. Okay, letterhead and signed is important for that. Okay, let's go to, this is a big one. Telehealth medical providers. In 2020, all of us were receiving our medical assistance from telehealth because of COVID, okay? No, very few people were leaving their homes to go get assistance. What else did we need a lot of in COVID? We needed a lot of therapy. So telehealth therapy became the norm, okay? And we're still doing it today. A lot of housing providers push back and say, no, we don't want to accept this because you only called a telehealth provider. They practice law in California. You met with them once for 15 minutes and then they sent you over a letter. I get it. Yeah, that doesn't sound very qualifying, but under the rules, it does. Okay. Now, the state of Florida does have a unique law that tries to push back on that a little bit. It talks about has provided in care or services to the tenant on at least, or I'm sorry, in-person care or services to the tenant on at least one occasion. That's Florida's version of saying you can use a telehealth medical provider as long as that medical provider has met with you at least one time in the past. That's the state of Florida. Remember, the Federal Fair Housing Act is always going to supersede any state laws that try to prevent it. So if a housing provider tries to stand behind this law and say, I'm sorry, you haven't met with your medical provider in person at least once, I'm guessing you're going to be able to say, yeah, but the federal law doesn't say I have to. Okay, the federal law says any qualified medical professional or professional that can provide this letter is good enough. And we have done our best to tell housing providers about this. There was another law that I believe was passed or at least trying to be exercised. This came to my attention 5 or 6 times from clients. Where the housing provider denied the accommodation request because there was a form that they had the tenant sign and they had their doctor sign. And on that form was a note or a question to the doctor saying, are you willing to speak on behalf of the clients, confirm their need for this accommodation via testimony in a court? Most doctors are going to say no or not or leave that blank. I'm a doctor. I'm too busy. Okay. And because they left it blank or they said no, a lot of housing providers said, sorry, your doctor didn't say they were willing to confirm your need as testimony in court. As attorneys, we would kind of laugh at that and say, if we need you in court, we'll subpoena you and you'll show up to court. We don't need your, approval and permission to say, sure, I'll come to court and speak on your behalf. That's not how justice works. So that law or that practice was trying to deny people accommodations, even though it doesn't make a whole lot of sense in the legal world. So every now and then you'll see local ordinances, state laws, and practices pop up that the tenant doesn't know. That's an obstacle that doesn't need to be there. Okay, you put up hurdles that probably shouldn't be there anymore. So it's up to us to kind of remove those. I believe we've talked about this slide. Yeah, the reasonability of it and everything like that. I know we're running low on time. So yeah, let's jump here. We got about 8 minutes to go. What questions does everyone have? Chat box. I think Alexis has it set up where if you want to speak, you can raise your hand or something like that. But what questions do you all have?
Yeah, definitely. Folks, digest what we've talked about. Feel free to drop your questions into the chat or the Q&A. And like we did last time, because we do have a little bit of buffer time here, if you prefer to pose your question verbally, what you can do is you can raise your hand in the participant list. I'll see that. And I can remove your mute and give you the ability to talk, because I know sometimes it's tough to put all of this into the chat or the Q&A. So if you do want to ask a question out loud verbally, just raise your hand and I will give you the power. And in the meantime, and Joe, Pia, if you see anyone with their hand raised, please let me know. In the meantime, what I'm going to do is just pop the CLE code information into the chat, not to end the discussion, but just to put it out there. The CLE code for this training is 2404525N, and it's 1 general CLE credit. That's in the chat, and I also said it out loud. See any hands raised? Not yet. So I know you rushed through some things, Joe. It's okay if you do want to, if there's anything that you rush through, that you have some extra time to go over. We don't have to take up everybody's time, certainly. But if there is anything that you want to quickly go back to or touch on, you have the ability.
Well, I'll just mention real quick, we're doing this boot camp series. We have about 6 different topics. Disability is the number one filed complaint for across the country and has been for several years. In fact, I think half of all complaints fall under disability, and then the other 6 classes make up the other 50% of filed for complaints. And most of the disability-based complaints are accommodation and modification denials. And a lot of it has to do with the simply lack of awareness and understanding on both the tenant and the housing providers sides of how are we supposed to make the request and how are we supposed to give the approval. So this topic today is it climbs the charts, and it's been sitting atop the charts for years.
All right. And so, Joe, something did come into the chat and someone did raise their hand. Totally up to you. What would you prefer to go with first?
So I'll look at the chat box first. Yeah.
And I'll read that question out loud just so everybody, in case someone's on the phone. Someone asked, are you surprised that some federal agency hasn't gone after the online service dog certification scams?
Yeah, that's a great question. So anytime there's a gray area in law, people from both sides are going to try to exploit it until it gets sorted out. So there's one side, you have people scamming the tenants saying, we'll give you certification for your emotional support animal, or pay $20 for this little green vest, and then your housing provider will have to say yes. Yeah, those are scams. The hardest part there is that that's going to be like consumer law scams. The reason why it's going to be hard to file under the Fair Housing Act is that those third-party scammers, they don't have any skin in the game. They're not housing providers. They're not denying anyone housing. So they might be exploiting an area of the law that's kind of gray right now, but I don't know what that fair housing violation would be. But I hope it gets cleaned up here pretty soon. On the other side, the housing providers, there's plenty of third-party organizations that are saying, send us all your money and we'll be the ones who do the research to make sure that your tenants aren't scamming you. It's not really that necessary. I've met with a few of them. They do good work, but I don't know how necessary it really is.
All right, thank you, Joe. So I see on the participant list, Donna has a question. Donna, I'm going to give you the ability to talk. You should be able to unmute yourself and pose your question now. I'm also going to lower your hand because I didn't do that last time and got confused. Lowering your hand, and Donna, go ahead and speak.
Okay, can you hear me?
Yep.
Okay, hi. So I actually have an open case right now. It's in Charlotte County. And it was initially a code violation hearing. My client has 2, right now we're classifying them as pets. They're pot-bellied pigs. And she was cited, for violating part of the code, but the code was really vague, and the special magistrate agreed with me that it's vague. And in the meantime, they are continuing the hearing, trying to see whether or not they're going to make an exception for pot-bellied pigs. And in the meantime, I was thinking ahead, and I was telling my client, well, maybe we can classify the pot-bellied pigs as, like therapy pets for her. And I was wondering, and I did, some research to see whether or not the Fair Housing Act applies to local, zoning laws. And apparently it does. So I guess my question is that like a good plan of action, just in case they do come back and say, no, these pot-bellied pigs have to go. We've, clarified the code and we're not going to allow them in residential areas.
I love that question. My mind goes to 2 places right away. Number one is the reasonability behind the request, okay? And who's being unreasonable? Is it the tenant being unreasonable, but that they're requesting a pig? Or is it the housing building codes that are being unreasonable that say you can't have that? Okay, which one's the unreasonable one? If the building codes have a valid, legitimate purpose that says, here's why we don't allow pigs to be on the list of domesticated animals or for whatever reason, because remember, this isn't just the housing provider saying no, this is an actual building code. So this is the county that made a decision somewhere that says this animal is not considered reasonable to be living in people's residential areas. They're going to have to be able to back up why. Because if they can't answer that why, then the Fair Housing Act is going to step in and say, then you need to make this accommodation. And the Fair Housing Act will remind the county, our federal law supersedes your county law. So if your local ordinances are in itself causing housing providers to violate the Fair Housing Act by denying people accommodations, then your building code is violating federal laws. that's where my mind goes right away. The second thing, though, I want to point out is you mentioned, what if we find a way to consider it an accommodation or an assistant animal or a motion sport animal? You want to get that timeline correct. If you're already battling keeping a pig, but you haven't asked for a reasonable accommodation as an emotional sport animal yet, and you don't have a doctor prescribing the need for it, your timeline might be a little tricky. It's going to show a judge or whoever it is that's reviewing this and say, doesn't look like it was an accommodation until you ran into the building codes. Now suddenly it's an emotional sport animal. That doesn't mean
Well,
it can't be.
yeah.
But yeah, what does
Okay.
your timeline say?
Well, she actually already got the
Okay.
doctor's note, but I guess that she was told she's supposed to like get them certified, and it's very expensive. It's like $500.
I've never
So
heard of that. A doctor's
yeah,
letter on letterhead signed by the doctor saying my patient requires this emotional sport animal. I mean, do you have, when you go to the pharmacist, does the pharmacist turn you away and say, I need this to be certified and notarized? Like, no.
yeah, I see what you're saying. But in this case, she also owns the house, so it's just the city that we're dealing with. But that's good information, because we can, come back to the county attorney and cite some federal law with this and see
Yeah.
where we go. Yeah.
Yeah, you have a battle of like federalism on your hands, and then the timeline is everything. Timeline really does matter in these situations. When was the request made? When was the doctor's letter signed? That can play a big role in the details.
Excellent. Thank you for the
Yeah,
information.
no, great question.
Thank you, Donna. I'm going to mute you now.
Any other
All
questions?
right. Yeah, that was a great question. I love
I love that.
the legal back and forth, the conversation about it. So, well, folks, what time is it? I always get mesmerized when
I know,
when
and I see that little chat there, Edwin. The skunk was a real request. It looks like the client just decided to move elsewhere. Yeah, that's actually pretty common. A lot of times we'll ask the tenant, what's your goal? My goal is to just live peacefully. All right, well, if you're not going to get that here, do you really want to go through the complaint process or just find somewhere else to go? A lot of people just find somewhere else to go, but at least now they're equipped with understanding of their rights and stuff like that. So that's a common result. Yeah, thanks for that.
Well, I appreciate all of you who posed your questions in the chat, came off of mute. I know it's tough when we're in, this virtual vortex, but really, thank you. And Joe and Pia, thank you for just always having such really great conversation and fostering that. Really, when I learn from you and I listen to you, it's easy. It's so easy to talk to you about these things. So thank you very much. Some thank yous coming in through the chat, of course. CLE code is already in. Reminder that this is being recorded and you're going to get that recording in your inbox, but you can always reach out to me directly. That's going to come from Zoom. And then, just a quick shout out. Like we said, this is a series. So May 7th, we're going to have diverse and inclusive rights for fair housing for immigrants. The 14th, Pride in Your Home, LGBTQ and fair housing rights. The 21st, we're going to do some VAWA and fair housing rights. And then on the 28th, we're going to talk about fair housing with family and children. So to be continued. All right, everybody. Well, thank you, Joe. Thank you, Pia. Thank you, audience. We will see you next week on Tuesday. Everyone have a great rest of your week.
Thank you all so much. We appreciate it. See you next week.
Bye.